Thank you for joining me, Bhavik.
Thanks for
Uh,
having me.
we've got a great showing so far. The notice on this must be good. I know this is particularly tough timing for you with the end of the year, and you do on the side manage a firm of a few people. How many attorneys did you say, Bhavik?
We have about 220.
So I'll go ahead and introduce you. Bhavik Patel, Sandberg Phoenix, a local regional law firm. I'll let you introduce yourself, but a man of many talents. Amongst them is managing the firm of a few attorneys, also a specialist in the estate planning arena and a number of arenas. But what we like about Bhavik in particular is just a great bedside manner with a topic that's difficult for people to get around to: estate planning, talking about death and dying. My name is Jim Matush, Trinity Wealth Advisors. What we do is bring a proactive look at your financial picture and all things that affect you financially. We do not invest money. We do hire and fire money managers and do a lot of advanced planning, like estate planning, where we bring in specialists like Bhavik Patel to look at what's affecting you in this area, the latest in the tax laws, and then some of the basics. Today will be a general overview, and then we'll get into some of the ways to make it more applicable to your family, give it more traction than just dying and reading a will. But Bhavik, anything that you would say about yourself to add a little color to what I've said?
Just hi, I'm Bhavik, and thanks for having me on. As Jim said, I am an estate planning attorney. This is what I specialize in, but I've been the CEO, managing partner of our law firm for about a decade now. And I started our estate planning practice about 22, 23 years ago. And I also was a faculty member at Washington University where I taught estate planning to the future lawyers in the space for about 8 years, and really appreciate being here and look forward to having a dialogue with you guys.
Vivek, what we really appreciate about you as a firm, having been introduced to you by a client that became interested in charitable giving. I know you speak quite extensively and work with the zoo here locally in some of their transformative planning gifting area. Made a huge difference with a client that didn't just give to the zoo, but it changed their whole estate plan. And what we like about you is that you take a topic that most people don't like getting around to. So everybody knows, oh, we need a will, or we need a trust, or we need to take care of this if something happens to us. But just getting around to it is tough. Could you start with just an overview of the basic documents that are critical in someone's estate planning? And then we'll get into some of the nuances of how to make it more impactful within your family.
Sure. And I'll actually take an even further step back and maybe even start by just saying, why is an estate plan important? And over the years, I've had thousands and thousands of families that have come and see me for estate planning. And listening to all of them, I've managed to summarize the whys that seem to be the most common. The most important why is I want to make sure there is family harmony if something happens to me. I want to make sure my children are not, that they remain in a very good sibling relationship with each other. I want to make sure my surviving spouse or whatever the case may be. So family harmony always seems to be everyone's true north. They want to make sure that what they want, there's a good plan for it, that the family is aware of it, and that nothing is going to disrupt that harmony depending on what could happen in life. So that's that. I would say that's the biggest, like the most common one I see. And then we get into some more specific ones. Planning for incapacity. We talk about death here and that being an uncomfortable topic, but there's also statistically a strong likelihood that at one point in your lifetime, you may become incapacitated, whether it be a mental illness or it be Alzheimer's or an accident. But at some point, we have to understand what the consequences are if I became incapacitated and how decisions are going to be made for me. And so planning for incapacity is a very big part of estate planning. I would say the most popular one that people always come and say, other than the family harmony, which is implied, is I don't want unnecessary administration and cost and headaches to occur because of me passing away or someone in the family passing away. And so that I can rephrase that by saying, I want to make sure I avoid probate. I want to make sure I avoid court involvement in what I want to do with my assets or my legacy or my wealth with my family. And I want it to be streamlined, and I want it to not be extensive from a time burden or as well as an effort burden. And I want my family to be focused on the grieving process and then the transition of what their new life is going to look like. And so that avoidance of probate is a very big step in accomplishing easing of administration. Some of the even more granular ones are I want to make sure my inheritances that I might leave to my children or even during my lifetime is protected from the things that could go wrong in our lives. I want to make sure it's protected from liabilities, or I want to make sure it's protected from creditors, or I want to make sure it's protected from potential future divorces. These are all very important things in wanting to make sure your design, your plan actually happens the way you want it to happen. And then the one that's a little bit more narrow is I want to make sure I'm tax optimized. I want to make sure I'm not unnecessarily paying estate taxes, or I've got it set up to take advantage of some income tax benefits that occur when you pass away. And I just want to make sure I'm not missing sort of those opportunities when I'm putting my plan together. As I define the common reasons, the whys, I think it's always important. I think those kind of summarize probably the most common of those reasons. So yeah, I just wanted to start there. Now I'll go into what I think is a foundational estate plan, if you want me to, Jim.
Please, I think that summarizes why we get along well and working together is because that we know our clients deeply. We develop these kind of proactive looks at taxes and their family and what they want going from whom to where and when and how it's best. As we all know, there's nobody that's equal. We'd like to want to think our kids are treated equally many times, but they aren't made that way. And then they get married and all of those problems. But before you get into the specific documents, it's so important that alignment is there. And starting out with those whys is probably why we get along so well. We usually come to the table with those things because we know people pretty well. And then you have this natural way to pull that out of people and they feel heard, which is not the common thing in your field, I might say. But in any event, now jump into the documents. And let me get you to step back and say, this is a problem for people because I once heard that half of attorneys die without having a will what is the number that you live with? You're an expert in this field.
It is unfortunate because the statistics that I have last looked at for families across the country is about 65 to 70% of the population does not effectuate an estate plan. And it's improving over the years as education and technology allows us to be able to educate people more and people hear about it more and those types of things. But it's still something that people put off. And I get it. It's not a fun topic. It's certainly not the topic I'm having when I'm having dinner with my wife or having drinks with my friends, or I'm not having that conversation about let's talk about death, right? So
getting around to it is important. Yeah. Now let me shift into make it really easy. What are the basic documents that you were starting to get into?
Yep. So I call that the foundational estate plan. This will probably be generally pretty universally applicable for 95% of probably the population. And then you customize them to meet those family needs and family goals. But there's four core documents is how I would describe the foundational estate plan. The first one is called a healthcare declaration. That healthcare declaration, the purpose of it is actually got two purposes. One part of it is often referred to as a living will or a directive. And what it really is doing is it's declaring your own wishes that you don't wish to artificially prolong your life when your entire medical team is making with certainty a medical determination that you really, my words, don't have any viability and your situation is not reversible. So I always tell people, think about really, it's a very narrow scenario here, but it's true end of life. And whether or not you want to artificially prolong that, or whether you want to be able to quality over quantity sort of type of thought. And that's one of the main purposes of that healthcare declaration document. The other main purpose has nothing to do with the end of life scenario. It's the everyday, day to day, who is going to step into your shoes and make medical and health related decisions if you can no longer make them for yourself. I always try to tell clients, think about like dementia. You might have dementia, but you might live for many years in that state. And if that's the case, you're not able to make sound medical decisions for you. Somebody has to be able to make those decisions for you. And then maybe even a little bit of a backup plan, like a succession plan of a list of people to make those decisions for you. What I want you to know, though, the biggest rule here I want you to know is no adult can make medical and health related decisions on behalf of another adult. So that applies to married couples. So my wife, if I did not take care of this, cannot make my medical decisions for me, even if I'm incapacitated.
Good point.
If we did not prepare this document, my wife would have to go to court to get the authority. And that's the stuff we're trying to avoid. There's a big difference between reacting to an issue or proactively planning around it and to avoid those issues. And the reaction would be we didn't get the plan put together and I became incapacitated. Now she's stuck having to go to court, hire a lawyer, more money, more time, a lot more stress in a situation that's already stressful. So,
particularly something they're not familiar with and they just hate the thought, fear, all of that.
yep. And then the thing I want to tell you is a healthcare power of attorney is super, super easy to accomplish. I mean, because part of the procrastination that is natural in this is I got to get to an attorney. I got to spend time. It's going to take me a long time to get the plan done, things like that. So I just wanted to make sure you hear powers of attorneys are really simple, straightforward documents. It probably could take almost less than a total hour to get the entire thing done and be ready to execute. So it's not a big ask on that. But shifting from that first of these four core documents to the second, we call it the durable or financial power of attorney. Now, just like the first document was for medical and health related decisions, think of this one for everything that is not medical and not health related. So, who's going to pay my bills? Who's going to access my accounts? Who's going to tell people like Jim what to do on my behalf? Or who's going to sign my tax return or endorse a check or deposit a check or anything you think of that you can do on a day-to-day basis? Somebody has to have that authority to do it on my behalf if I can no longer do it. And again, if you don't address it, you're back to court trying to get that authority. The thing about the financial power of attorney, I'll give you just a really crazy, again, marriage does not do this. So my wife and I, let's say, own our house together. Her name's on the deed, my name's on the deed. We own this house together. If I became incapacitated, and we did not have this power of attorney document, my wife would not be able to do anything with the house, even though she owns it, because she does not have the legal authority to sign my name on anything. And so,
Unless you have that power of attorney in place.
correct, or a court order that gave it that authority. And that's again what we're trying to avoid. If you hear court, dollar signs should be going through your head. Like, it's unnecessary cost and expense and time that you're now having to spend to actually get things done when things need to get done. So that's that second document. These first two documents I just highlighted are lifetime only. So they actually have nothing to do with death. And we're talking about them in estate planning, because estate planning is so much more than just death. It's everything. It's what's going on now. It's what goes on if you become incapacitated, and it goes on beyond what happens when I pass away. And so these are lifetime only. They only apply during my lifetime, and they only really have effect, for the most part, if I'm incapacitated. I don't know if you want me to open it up, or you want me to just keep going.
You hit the 4 documents, and then I'm going to open it up to questions, which, by the way, use the chat box. I see we've got quite a group here. Use the chat box at any point if you need clarification. But go ahead, Bhavik. I want you to hit the 4 documents, and then we can jump into how to create more impact with these.
Great. So the third and the fourth document really work together. They're referred to technically as a last will and testament, which we just refer to as a will. And then the fourth document is a trust. And I'm going to be at a high level here, and there's tons and tons of different types of trust. Won't necessarily go into that, but it's important to know how these two documents work together. And there's a couple of things that sometimes people aren't fully aware of. They come to me and they say, I don't have to worry about probate because I have a will. So let me clarify a couple of myths that are out there in this space. First things first, a will does not avoid probate. So if you're easing administration as one of those core reasons for wanting to do this, and you have a will does not avoid probate. In fact, it does the exact opposite. It only functions if you go through probate. Now, I'll come back to the will in a second, but I wanted to dispel that myth. The second myth is a trust is only for the uber wealthy. And that is furthest from the truth. The major, primary, number one reason for a trust is because it's the most comprehensive way to avoid probate, and to also be able to say, what do you want to happen to your estate when you pass away? Now, I'm going to give you a little visual here. Think of the trust as a shoebox sitting in front of you. And what you want to do with that shoebox is you want to connect all of your assets in one way or another to that shoebox. And if you successfully connect that trust to all of your assets, then you will have avoided probate on all the assets that are in the shoebox. I'll come back to the trust again here in a second, but now I want to connect the will and the trust. The real purpose of the will is, think of it as a big safety net around your shoebox. And if you forget to connect an asset to the shoebox, it picks up and catches all the things that you did not connect to the shoebox. And those will be the assets that potentially would have to go through probate. And then the purpose of the will is to tell the probate judge where those probated assets should go. And the will be real simple. It's going to say it's supposed to go in the shoebox. So it catches anything you did not put or connect into the shoebox. It has to unfortunately go through the probate process, but it eventually gets it into the shoebox.
Sometimes called a pour-over will?
Correct. Yep. A lot of times it is referenced as a pour-over will, but
But that's the most comprehensive way to avoid probate. And I can see a question already coming up here on what if you have one child? As a matter of fact, we have a fairly recent situation where someone came up and a trust was put together by a mother who they didn't understand what they were doing. It put something, the clients actually dissolved the trust and they only have one child, so they said, oh, we're putting everything in. So speak to that, because you've got simplicity in your situation and you have one child, is setting everything up with the payable on death accounts. Does that do the same thing? But you'd still need the healthcare directive and you'd still need the durable power.
Yeah, POD or payable on death or transfer on death or beneficiary designations also avoid probate, and they go to that beneficiary. So it could potentially be the right strategy for that individual. It require a conversation, right? So things I would be asking is, how old is that beneficiary? Are we wanting that beneficiary to have unrestricted or full access to that money at that time of passing? Because sometimes that answer is different depending on the stage of what's going on in that individual's life, whether they're in college or not working or working might be factors we'd evaluate of whether they're fiscally responsible enough or ready enough to be able to receive that inheritance. But there's some downside to those immediate direct transfers, because once the individual child receives it, it's theirs. And it's theirs, and it could be subjected to whatever could go on in their will. So yes, it avoids probate. Remember, there's multiple reasons to do an estate plan. One of those reasons is to avoid a probate. So it would be successful to accomplish that objective, but maybe it's not the right design for your estate plan. So actually, before I maybe go more into that question, I'm going to continue on by explaining the shoebox.
Okay.
All
And
right.
let me correct something. I've already been corrected myself. Use the Q&A box down at the bottom of your screen. If you'll use your pointer, go down there. That's where, if you're listening and you've got a question, that question I just got, use the Q&A and I'll have that one answered. But keep going
Right.
there.
Thanks. Okay, so the shoebox. Every trust has 3 identifiable roles in that document. Okay, the 3 roles are grantors, trustees, and primary beneficiaries. When the role of the grantor, let's talk about that. That is the person that is designing the shoebox. It's going to say what all it needs to say, where things are going to go, how are they going to go to them, what limitations or restrictions do you want to put, if any. All that's the design of the shoebox. That's really the design of answering the question, who gets what, when, who dies when, and how. And it really is truly the definition of estate plan. If you think about it, it's what your family, you and your spouse, if you're married, or you, if you're not, what you want to happen to your estate. So the grantors design that. They are the ones that decide what they want to do with their assets when they pass away. And so the other thing the grantor gets to do is they get to redesign or modify the shoebox at any time during their lifetime. So the grantor, one of those 3 roles, is creating the trust, designing the trust, and tweaking it as they see fit throughout their lifetime.
I know that's a very important one, Bhavik, because people will say, I don't know. You don't know when you're going to die. I'm young at this point. We just had a 45-year-old that had a considerable net worth and was talking about that and had already experienced the death of a first spouse. And the point being, you never know what's going to happen. You can change these documents, but
Right.
it points out the very significant importance of having somebody that you can understand, that makes it simple like this. That's what we love about what you bring to the table, Bhavik. Keep going.
Yep. So the second role is the trustee. Think of the trustee as the person in control of the contents in the shoebox, and they can lift the lid up, they can put things in, they can take things out, they can rearrange them, and then they can close the lid. Trustee controls all the decisions about the assets held in trust, and they have one important job. That job is to act in the best interest of the third role, the third role being the primary beneficiary. When you create this on day one, you or you and your spouse, depending on your family, are all three of those roles. And the thing is, during your lifetime, when you serve in all three of those roles, there is nothing different than how your life is today. It's your money. You get to do whatever. It's no different than if it's money in your pocket or if it was money in the shoebox. Because when you're all three, you have the freedom to do anything you want to do. Like I said, it's your money. You get to do whatever you want. You get to use it. You get to invest it. You get to spend it. You get to give it away. You get to do anything you get to do now. So during the grantor's lifetime, when the grantor is serving in all three of those roles, it's no different in your life today. The shoebox and the design of the shoebox starts to dictate what happens when things start to change. And so the most basic sort of design of a trust is a family trust where husband and wife serve in all three of those roles. The trust or the shoebox, what happens when one of you passes away, it pretty much stays exactly the same. It's just there for the surviving spouse to continue to operate in all three roles. No different in a joint account. If somebody passed away, it would just go to the other surviving joint owner. That's the same concept of these family trusts. If you're married, and if you're single, then it would be the same as if the married couple passed away, which is the next scenario, the next part of the design. That's when things start to change because you're no longer the grantor because you've passed away. There's no one that gets to become the grantor. That's when your wishes are now carried out. And so what would happen is there would be a trustee that would step in to be able to administer your trust. And what does that mean? It means pay your taxes, pay your debts, pay for your funeral expenses, things like that. Gather all the contents that were in the shoebox, figure out what it's all worth, and follow the instructions of your design. Your design may be as simple as when mom and dad pass away, that administration occurs and everything splits equally to my son and my daughter. That could be your design. And if that's the case, then the shoebox would basically be a chainsaw in half. And there'd be two buckets, a bucket for your daughter and a bucket for your son. That bucket could be immediately distributed to your son or daughter, or it could stay in the bucket for your son and daughter with rules. And maybe one of those rules is my son or daughter are not quite ready to have that full access to that money and maybe make sound decisions because of their maturation stage, their phase in their life, their age, whatever the case may be. And so we might want to design that the buckets have a gatekeeper, someone that they need to get permission to use the money. The fun example I always give is I have young kids right now. I have basically almost a 16-year-old and a 13-year-old. If my wife and I passed away, if my children's mom and dad passed away, my son would 100% at 16 say he needs a car. And he might say, I want this nice little Lamborghini that I saw the other day. And my brother, who's my gatekeeper, is going to say, yeah, it's a really cool Lamborghini, but no, that's not the car we're going to get you. We're going to get you this Honda Accord. Like, I'm being silly in my example, but I'm trying to tell you that's the function of that gatekeeper, which would be that trustee, that backup trustee. And that's how the trust would work. Now, I wanted to at least finish
Vivek,
that
let me
conversation.
interject
Yep.
while you're on that, because I just had a question where someone said, what if you don't want your beneficiary to have to ask someone for that? And it's a small segue, but what if you didn't? And this is the situation I was talking about where there's just one daughter.
Yep.
And they have had, this particular client has had nightmares with the problem with the trustees and asking an uncle that was aged and very difficult. So, what if you don't want the trustee to have to ask someone? I'm sorry, don't
Yep.
want the beneficiary. I gave away
Yep.
the answer, but go ahead with that.
Yeah. So there's a couple. First of all, that's why an estate plan is truly unique for you. These are the tools, the vehicles used, but they are as flexible as you need them to be for your situation. So if I was having a conversation and had one daughter, Emily, and I was going to leave Emily everything, and I think Emily is perfectly responsible and she doesn't need oversight, and I'm not worried about it at all, I have two options. I can either just distribute them. I can say my plan, my design of the shoebox could just say that when I die, the shoebox goes away and all the money just gets distributed to Emily. That's no different than the TOD designation at an asset level. And then Emily will get that and she'll deposit it into accounts and that's just now her money to do whatever she wants to do. But that money would then be exposed to what could go wrong in Emily's life. So if Emily got in a car accident, that money is exposed to it. If Emily was married and then subsequently got divorced, that money could potentially be exposed to it. So there's a little bit of vulnerability to that simplicity, and there's some give and take. You have to be okay with not protecting that money. Now, alternatively, you could have your cake and eat it too, potentially, and you can leave. My shoebox could stay intact and Emily could be the primary beneficiary, but Emily could also be the trustee. She could be in control of her own bucket where she's asking herself permission to use the money, which is the same thing in functionality and in practicality of whether you just gave it to her, except when it stays in the bucket, the shoebox, it's protected from what could go wrong in her world. It's protected from her liabilities. It's protected from a potential divorce. Those types of protections are awesome and are hard to get in any other way. So if it's the design is going to be who should be the trustee. If Emily's right for it and she's ready for it, great, it's Emily. If she's not, maybe it's a temporary gatekeeper. Maybe it's the uncle only until Emily turns 25. And then it's Emily. And we can design the trust. That's why I describe the trust as the most comprehensive way to be able to address everything that's unique, what's worrying you, what's not worrying you about leaving money and wealth to someone else.
There's so many horror stories in this that people hear about bank trustees. I know we rarely recommend them. You probably do far more often than we do, but mainly because of this having to ask for money and fighting that fiduciary interest that the bank wants to keep the assets. And I maybe said more than I should have here on the webinar, but in any event, people do ask us about, boy, I sure hate having to ask for your own money. And that was the particular question there.
Yeah, and that's why the design of these things are so important. It is definitely not a one size fits all because no family is the same as any other family. And so it's a dialogue, it's a conversation. It's not, to be honest with you, we try to have fun with it. We make it pretty easy, very comfortable to do. But
fun with estate planning? Oh, unheard of. Bhavik, I have another question here that comes up fairly frequently when people are entering poor health seasons, Medicaid, how to protect assets. And the question was, would this trust be able to protect assets so that you could apply for Medicaid? And I know if you can give a short answer to this one, I'll be surprised, but that's generally a pretty complicated maneuver in the world we live in.
So look, right now I'm just talking about traditional foundational estate plan. And this that question would not fall into a foundational estate planning strategy, right? That'd be more of what we call elder law planning and saying, I would rather preserve the assets I've built throughout my lifetime to go to my family versus going to my long-term care needs. And I'd rather have Medicaid maybe help cover some of those. And how do I do that? And that there are many different types of trusts, many different types of trust. And there is a particular trust, but not the one I was talking about, where you could secure a portion of your assets such that they're guaranteed to pass on to your children and not to your end of your elder stage of your life care. But then there's all kinds of rules around it that I'm probably not going to dive into for this.
That gets the complexity. And if you're interested in that, folks, we did a whole webinar on long-term care planning with Mike Padower. Did a really good one on how to plan for those long-term care needs, because that is a real legitimate liability. And trusts are not the only way to plan for that. But keep going. Or actually, Bhavik, I wanted to steer this. You mentioned having fun with this. One of the biggest problems that we see is people will do this estate plan. It's kind of like pulling teeth. They get the documents done. They get these 4 foundational documents done, or 3, whatever is the case for them. We love to get into whether a trust is appropriate or not. I love the way you described having your cake and eat it too with a trust. And the question is paying now or paying later or protecting, and how important that is for you. But I really wanted to look at the way to make your estate document for your family if your why is I want family harmony. And many times today, family harmony, particularly when you get to several kids, is difficult. Let's talk a little bit about having more impact with what you've put into these documents. What are some secrets that you use?
It's listening, really, more than anything. That's the secret sauce. It's hearing the families that come see me and learning from them directly what is the important things on their minds. What's the parts that are making them uncomfortable, or what's their fears, what's their concerns. And once you learn those, the fortunate fact at this point is there's a lot of experience that we bring to the table to provide multitude of options that would accomplish those goals, but might address one fear differently than another fear. And then we talk through it. And so, like, just illustratively, like for an example, here's a really common one. Family comes and sees me. They have a family business. They have a son, and the daughter's in the business. The son's not. And we're going to talk through that, and we're going to scenario plan around it, and we're going to try to, and we're going to get from a conversation, a real, vulnerable, open conversation as to where the fears really are. And perhaps the fear was the daughter is going to get this business and the son doesn't want to be in the business, but mom and dad want to make sure their estate is evenly split as possible. Then that's great. We'll talk through that. We might go through an exercise about what the business is valued at today, and we might even communicate with the family transparently and say business is valued at this today. So when she gets that, we're offsetting it with this. Maybe we might need to pair it with some life insurance to be able to have enough to equalize the values of the estate. It could go in 87,000 directions, right? But it's a dialogue and it's a conversation to really learn what the real worries are for that family. And then there's some coaching as to communication being the key with the family members. Harmony is not kept with surprises. Harmony is kept with transparency and direct communication, which we can help you navigate, and actually sometimes are asked upon to have family meetings to actually share the design with the family.
That's so important. What we call it is knowing intent. So first of all, it's your assets. You're the one that accumulated these things. And we know kids have different interests, but you have the ability as the grantor or the person that's in charge of your will, your documents, to determine this is what I want to happen. This is what's important to me. Then communicating that intention is so important. And for some people, some families, it's difficult to talk about that. But we've now got families that are 3 generations with us, and explaining that intent and letting them know. Sometimes they ask us to be the voice piece to do. But what we've always found almost every time is that once you get people talking about it, it's a whole lot easier. It's a whole lot. Any other thoughts you have on that with explaining the intention, the communication, what we want, what we wish? And that's okay if you don't like that or you don't appreciate it, but that's what we want.
That's exactly right, Jim. That's what avoids surprises. As I was mentioning earlier, surprises is not correlating to maintaining family harmony. And it's also healthy. Conversations with your family about these things are a help at the right time. You're not having a conversation with your 7-year-old, right, about this. You're having this. Right. So there are times where the conversation needs to be timed right, but it is super important to engage everyone in the family to make sure that cohesion stays.
Here's another question that was brought up, Bhavik, was, did you describe the trust for just the uber wealthy?
The exact opposite. I said that was the myth, that people thought that maybe a trust was for the uber wealthy. And to me, the trust is an absolute for everybody, in my opinion. It has all the freedom and all the flexibility you could possibly have to do things, and you can address anything. In fact, a trust versus just a will, I would say a trust is far more important than the will, because remember, the will only addresses probate, and that's an issue. I did fail to mention one other very important part about the will. It is also, if for any of you on this call that have minor children, it's the only document in your estate documents that really get to state your preference on who's going to take care of your minor children if something happens to you.
Guardians, yeah.
Yep. And that gets put into the will as well. So for what it's worth.
One of the things that we describe, and I'll steer the conversation here in the next 10 minutes or so, is that impact. So if you've worked hard, you've built a business, you've built a net worth, a savings nest egg that is important to you. And even if you haven't, you want to spare your kids from the next generation from the difficulty. In fact, Bhavik, what is the average time if someone dies intestate without wills or trust? What's the average time it takes to settle that?
Yeah, I know that the average probate time is about 12 to 18 months.
12 to 18 months. So and not something that is fun. So getting around to this is important. But now let's switch to, you've hung on to your money, and many from our perspective hang on to money because they want financial independence, they want a retirement, they do want to pass something on to the next generation. I love the way you started out with whys. We like to get to that right up front with, why do people hang on to money? What is their purpose for money? But in determining that and looking at that next season, often once you've reached, what we find is once you've reached the age of 60 or so, you realize, oh, I've been here longer than I'm going to be here. And if I have enough, which is often a question, do I have enough? And we love to answer that question, getting into what can I expect? What kind of income stream? How far will this go? Because many people, particularly business owners, don't understand, how can I convert this to some kind of income stream or make it liquid or what have you. But once you know that, then it's like, what is the legacy? What is the impact that I want to leave on those? And I love the question that we often ask is, what's more important to pass on to the next generation, your assets or your values? And that tells us a lot about people's why. Some, I got to tell you, some people are very much, I don't care. It's their money now. It's their problem. But most people are much more towards, they have that strong intention. And any thoughts you have on that legacy or impact that money can have on the next generation. Most people are aware of some of the problems that have happened, particularly here in America with entitlement.
Yeah, no, it is absolutely probably one of the largest parts of a conversation we have with families. Okay, now that it's going to your children, and we even alluded to it a little bit earlier, what rules do we need to put in here to ensure that the behaviors that you wish to instill upon your next generation are not being conflicted with the access to wealth? And that
Yep.
is really your own story to create, your own painting of the shoebox. So I have just give you like a general list of like things that some people are education super critical sometimes. Some people are super critical about, I really want them to ensure, I want my children to be educated. That's a super important part. And so we might bake into the design certain requirements of access to the money or freer access to the money once you've obtained 4-year degree, or maybe it's even beyond that. Once you attain a medical degree or a law degree or whatever the case may be, then you have other value issue considerations. Really are concerned about certain addictions, drug addictions, alcohol addictions, gambling addictions, spending addictions, whatever the
I
case
have
may be.
I have a question just came in that
Yep.
says, what about work ethic? What about
Yeah, I
passing
was going to
on
give
work
that one
ethic?
too. I got an example there too. Absolutely. But on the addiction one, since I was just talking about, I'll finish that. There may be certain rules about distributions aren't allowed unless you've shown objectively certain improvements or that you've taken and facilitated and gotten help you need, et cetera. Or even as granular as no distributions are made unless there's a clean drug test. Again, I'm oversimplifying for the purposes of a few minutes left to talk through it. But now the question about work ethic. This one comes up quite a bit. And I will tell you, there's lots of ways to address that. First of all, I'd require a question about what is your definition of work ethic, right? But sometimes we tie distributions to the ability for that beneficiary to have a job. No, we're not gonna provide extra distributions unless you have a full-time job, so on and so forth. Or that you are actually going down a career path, and then we would talk about what that means, and we would tie. And these are the types of trusts I'm talking about here. These buckets are incentive buckets. What kind of incentives or values prolongation are we trying to create here? And so you give me any issue, and probably could talk through really any kind of like general kind of language we could put in the document. And that's how the conversation is going to go. Once we get to that point of the conversation where I'm learning this is really important to you, then we're going to say, okay, here are a handful of ways I've addressed it in the past. Any of those resonate? No, or that's, but I really think about this. And then the conversation just free flows. It's like, I really think this meeting is you're an artist and you have a blank canvas and you're drawing your picture. That's how that conversation evolves.
That's why we've enjoyed. I know how we first met was over a special needs situation, special needs client situation where they had a daughter that's now in the 50s. And you were able to satisfy the concern that they could be protected and then have some charitable intention even after that, just by addressing what those needs are. Which leads me to one of the things we often talk about. We call it stewardship. When you've spent a hard life of hanging on to money, building up something that you have a lot of. Pride may be the wrong term, but it didn't come easy. You scrimped and saved or invested or worked hard to build something that now you want to make sure that responsibility of doing it well is done well. And it's not just oh, I won the lottery, what do I do with it? Which is pretty much our experience. I'd be interested if you've seen this otherwise, but a way to ruin your life when it easy come, easy go kind of thing. But any thoughts on that, Bhavik?
Yeah, I think what kind of impact do you want to give to the civically and socially are big parts of the conversation. And there's strategies there. I want to provide something to my alma mater. I want to provide something to my church. I want to provide something to this organization because that organization was hugely impactful to my daughter who has Down syndrome or whatever the case may be. And so we talk through that. And the strategy might be you have an asset on your balance sheet that has a lot of built-in income taxes to it, like your IRA or your 401k. And just for a simple math, $1 million IRA really is only worth, let's say, 600,000 or 700,000
After taxes.
after tax and actual use to your beneficiaries. So that particular client you were talking about went through that exercise, and we had those conversations, and we talked about you wanted to give some amount of money to this organization. If we use your IRA money to do it, you might give them a little bit more, but it's actually less you're actually taking away from your kids from a net effect perspective. So they were able to find that balance really well that accomplished all of the things they wanted to, and they cared a lot about their impact to that organization that was really important to them. And so we balanced the plan to address exactly how to do that. That was a real example of one. And so those are the things. That's why I think it's more of an enjoyable conversation and not one to put off, because it's not about the fear of dying, what's going to happen at death. It's more of these are things that matter to me and I want to make sure they happen. Like that impact is a big part of it.
Yep, that's when you've built something that you want to pass on to the next generation or some type of community purpose or something that's important to you. Doing that well can be hugely leveraged by the way you go about doing it. Bhavik, thanks for joining me here. We here at Trinity love shaping, forming that purpose, that impact, that reason, that meaning for money that you have created and saved and built and purposed. We love helping people define that. And I love the way you make it easy and actually, I could say fun. So you've done so here today. If you have, this will be sent out, a copy of this will be sent out to everybody that signed up. And if you'd like to forward it on to anybody, please feel free to do. Reach out to us. We're happy to talk further, define a question. In fact, right before we leave, Bhavik, would you type in your contact information? I'll type in mine so that people have that if they want it. Jim Matush, Trinity Wealth Advisors here in Kirkwood. Our number is 314-966-0033. Bhavik?
Do you want me to type it in or just say it?
Go ahead and say it so we have it on the line, and then if you'll type it in as well.
Yeah, my email is bpatel, BPATEL at sandbergphoenix.com. And then my phone number is 314-446-4310. Feel free to call if you have any questions or want to just talk more about this. I'm always happy to talk to people about estate planning.
Great. So thank you for putting that in there. I added mine as well, jmatush at trinitywealth.com. So look forward to answering some questions. Oh, here's one more right before we sign off. Also, we will add in the email that goes out to everyone that signed up for this thing and is here today. We will include that on the reply email. Oh, here's very informative. Thank you for the input there. And Bill, we'll look forward to talking to you later about it. Bhavik, thank you for joining me. And till next time, maybe we'll get into that. Describe real quickly, Bhavik, that thing that just hit, and is it before the end of the year, that minority business interest?
Yeah, it's so specific, but there's a type of certification that business owners can get called the Disadvantaged Business Enterprise Certification. It's a powerful certification, but there's a new rule that just disqualified everybody and then required having to reapply with very specific requirements. And so we've been helping navigate family businesses that are DBE certified to maintain that certification. So there's always something new, always something changing.
Always something new and coming down the pipe from Washington, D.C., I guess. At any rate, thank you for joining us today. Until next month, I believe we've got something on tax planning and getting it done before the end of the year.
Yep.
Thank you
Thanks
for
for
joining.
having me.